Hello, welcome back everyone. In this session today we're going to look at liquidation process under IBC. So in the previous couple of sessions we have looked at the Corporate Insolvency Resolution Process. Now let us understand what is the liquidation process as stipulated under the IBC. So liquidation is generally regarded as a last resort under IBC. The primary focus of IBC is to keep a company as a going concern and to, if in case it has the potential to survive under a different management, for it to grow and thrive in the market. But liquidation is considered as a last resort. As per liquidation, you dissolve the company, you sell off each individual assets of the company. Basically, the company is torn to parts. It's considered as the death of the company. And such a drastic step needs to be taken after resorting to every single possible option there is. This has to be the absolute last resort, and hence, since a company cannot be revived once it is liquidated, it has to, such a grave decision needs to be taken after much scrutiny. But liquidation is also, as everything else in IBC, is also strictly time bound and a transparent process. It provides for a fair asset distribution. We will look at how the assets are being liquidated and how the assets will be distributed amongst various stakeholders. That is a very crucial aspect that IBC has brought in, the waterfall mechanism. We will look at it in the subsequent portions of this lecture and the next. So the liquidation of a corporate debtor is governed by sections 33 to 54 and also the IBBI, Insolvency and Bankruptcy Board of India Liquidation Process Regulations of 2016. Both of these combined, so the liquidation process regulations provide for the procedural aspect of how a liquidation procedure is to take place. It provides a timeline and specific duties that a liquidator has to undertake, and the section provides for the substantive part. Now, let us understand what are the triggers, various triggers for liquidation. So, section 33 provides for initiation of liquidation or the order of liquidation. So, let us understand under what circumstances a liquidation order is given. The adjudicating authority may give liquidation order under certain circumstances. If, in case, there is no resolution plan within the stipulated time, within 330 days, and there does not seem to be any scope for any, even after extension of time also, there does not seem to be any resolution plans in sight, and the corporate debtor seems seems to be in a hopeless state. The adjudicating authority may, upon its discretion, consider that this is a failure of CIRP process for that corporate debtor and order for initiation of liquidation. Or it can order for liquidation if a resolution professional files an application before the adjudicating authority stating that the committee of creditors, in their commercial wisdom, have opted for liquidation, and for this application for liquidation to be filed, the committee of creditors need to convey their decision with 66% voting majority. As we have seen in the previous class as well, committee of creditors need to take any major decisions other than the withdrawal of the CIRP process with 66% majority. Even for approval of resolution plan, the committee of creditors need to approve it with a 66% majority. So let us understand what the COC needs to examine before opting for liquidation. So similar to the IBBI liquidation process regulations, the CIRP process is also governed by the IBBI CIRP corporate persons regulations for corporate persons, wherein regulation 39 BCD provide for the aspects that are to be required, that are to be looked into by the committee of creditors prior to either approval of the resolution plan or prior to approval of the liquidation. So let us understand what are these aspects. So if in case a resolution plan is to be accepted, the resolution plan needs to comply with certain criteria provided in Regulation 39, which provides that operational creditors need to be paid in priority. Dissenting financial creditors, as in the creditors who are not voting for the resolution plan put in front of them, not voting for the or voting against the resolution plan that is ultimately going to be taken up or considered approved. Suppose say a dissenting creditor holding 10% of voting share, a creditor holding 10% of voting share decides to go against a resolution plan, and that particular resolution plan is taken up as and considered as approved after having secured 66% majority. That such creditor who has gone against this particular resolution plan will be considered as a dissenting creditor. So 39, Regulation 39 provides that such creditors need to be paid in priority. Primarily, it is insolvency costs, as we have already seen, insolvency costs, operational creditors, and dissenting creditors. These stakeholders must be paid in priority. So, Regulation 39B provides that before the resolution plan in accordance to Regulation 39 is accepted or liquidation is opted, the financial creditors are required, the committee of creditors are required to have a look at and accept a preliminary estimate of the liquidation costs. So what the resolution professional here does is he will compile an estimated cost as per the requirements of the creditor, the scale of operations, and the way the insolvency proceedings have gone. And as per the industry standards, the insolvency professional will create a table of estimated liquidation costs. It includes the paper publication costs and all of the costs required for application, the legalities, and such other things, and provide an estimate as so that the committee of creditors have an understanding as to how much, if they are for liquidation, how much is it going to cost. So the resolution professional not only provides the liquidation cost, but also provides a liquidation value of the company. As we have seen in the previous sessions, a registered valuer is appointed, two registered valuers are appointed, and the aggregate of the registered valuer's findings will be taken as the entity valuation. Amongst the valuations identified, the liquidation value is the lowest possible value or the minimum value that will definitely be achieved upon the sale of the assets will be taken, and if this liquidation value and the estimate of liquidation costs, so the creditors are to look at this. If the liquidation value it's is substantial enough for, if in once the liquidation costs are once the liquidation is done, if it will be enough to cover the costs, and whatever is remaining, that will be distributed to the committee of creditors and the other stakeholders. So they are to look at if the liquidation value, if the resolution plan is offering a higher amount than the liquidation value. Naturally, if the resolution plan is providing a higher value, only the insolvency costs will have to be catered to, and subsequently all of the other parts, all of the remaining amount will be distributed amongst the stakeholders as provided in the resolution plan and as agreed by the committee of creditors. Instead, they will naturally, in their commercial wisdom, not opt for a liquidation value which is lower than the resolution plan. So they are required to consider this aspect. Regulation 39B of CIRP regulations, and coming to Regulation 39C. 39C provides for compromise and arrangement. So if in case the the committee of creditors, prior to approving the resolution plan or opting for a liquidation, they are required to explore if there is any opportunity for compromise or arrangement. Compromise or arrangement as provided under the Companies Act, Section 230 of the Companies Act. So any scope for mergers or acquisitions or such other things as provided in the Companies Act may also be explored by the Committee of Creditors. And this needs to be explored within the resolution. If the Committee of Creditors are open to exploring such an option, the resolution professional is required to look into such options and propose something within 30 days, and within 90 days such compromise or arrangement application must be filed before the adjudicating authority. But for whatsoever reason, if such compromise or arrangement fails, this 90-day period would not be considered as part of liquidation. The liquidation commencement date will be considered subsequent to the closure or conclusion, whichever way the compromise and arrangement is going on. Suppose, say, on the 90th day, they decide that they are not going to go through with the compromise and arrangement put before them, then the liquidation commencement date shall be by order of the adjudicating authority as per whenever they stipulate it, whenever the liquidation order is expressly pronounced. And 39D. 39D provides for the the sale of a corporate debtor as a going concern under a liquidation. So as you are going to see in the subsequent portions of this liquidation process, liquidation of an entity can be done in multiple ways. And since the primary aim of IBC is to ensure it continuing as a going concern and to not to rush corporate death, which ultimately affects the economy gravely, the code provides for even under liquidation, the corporate debtor may be sold as a going concern. What does that mean? That means in case a corporate debtor has multiple functioning units, and each individual unit can also function separate from the entirety of the corporate debtor. Say, suppose a company has, let's see, if it is a clothing industry, a company has uh, the textile weaving part, and it has probably, say, suppose the stitching part of something. So both of these units of the entity can individually also sustain and cater to the market and different clientele. Like the weaving unit of the entity can have different clientele and not just cater to this corporate debtor. It can have multiple third-party clients and can sustain itself on an individual basis. And at the same time, the other unit also may sustain itself. Then such functioning units of the corporate debtor may be sold separately, so as to keep the corporate debtor as a going concern even under liquidation. So these are the aspects that a committee of creditors needs to consider before approving either a resolution plan or opting for liquidation. Also, the before approving liquidation, the committee of creditors also need to decide upon who the liquidator is going to be and how much is he going to be paid. So for the liquidation, either the resolution professional may continue, or the committee of creditors may propose another insolvency professional who also meets with the criteria as of the resolution professional. He should not be a related party. He should not have any disciplinary proceedings pending against him. He should not belong to any insolvency professional entity that is a related party, or should not have such partners or directors of the insolvency professional entity should not be representing any of the other stakeholders in the same CIRP process or liquidation process. And the insolvency professional is required to submit a consent form. If all of these criteria are met with, then such insolvency professional may be appointed as the liquidator. So earlier in the resolution professionals were it was common practice that once the resolution professional is confirmed, he may also, upon the discretion of the committee of creditors, continue on as a liquidator if such need arises. But in the recent past, the IBBI has given out a notification, a circular, which is a suggestion, actually not a mandate. It suggests that the liquidator and the resolution professional need to be different insolvency professionals. So it is so under liquidation processes, the fee that is realized by the insolvency professional is on a percentage basis and on a performance basis. So the net realization within each of the milestones, and the percentage of the total assets is also critical in determining the liquidator's fee. So it is understood by the IBBI that this fee structure may so act as a trigger for either the committee of creditors or for the insolvency professionals, even though not to question their morality or professional ethics. This may influence their actions during the CIRP. So if they are no longer able to uh, act as a liquidator as well, then it is their hope that the CIRP process will be undertaken with much more diligence and may see a successful resolution. Now, coming to the next one, breach of approved resolution plan or implementation failure. So, as we've seen in the previous session, for the implementation of a resolution plan, it is necessary for the resolution plan to have a monitoring committee. A monitoring committee comprising of the resolution professional, representatives of the resolution applicant, successful resolution applicant, and the representatives of the committee of creditors. So, if it is found that the resolution plan has not been executed within the stipulated timelines for whatsoever reason, it could be non-compliance by the resolution applicant, or it could be non-cooperation by the corporate debtor, the resolution professional may approach the adjudicating authority and they may file an application stating that such implementation is has failed and um, they're not going to be able to continue with the implementation of the resolution plan. Then the adjudicating authority may order for a liquidation of the corporate debtor. So a resolution, or if the resolution plan does not meet with the criteria that are stipulated in section 31, if they do not meet with the essential criteria and does not contain all the mandatory contents of a resolution plan, then such resolution plan also may be rejected and liquidation may be approved for the corporate debtor. In case the liquidation is ordered because of non-compliance of the resolution plan, the resolution professional who has made such application in the first place cannot act as a liquidator under this provision. It is seen that resolution professional has not, if he is not able to comply with the provisions stipulated in the code, then he may not be appointed as a liquidator. Or direct order by NCLT. So the NCLT, as per its discretion, if it is found that it is in interest of a greater public interest, or if the resolution professional or the committee of creditors have mismanaged the CIRP, may order for either uh, they may direct the IBBI to suggest the name of another insolvency professional, and within 10 days of such order, the IBBI is going to recommend someone along with their consent form, and the adjudicating authority shall appoint such insolvency professional. So now let us understand initiation of liquidation and what happens upon initiation of liquidation. So once the NCLT orders for liquidation, a moratorium of sorts is imposed. The moratorium under liquidation is not as exhaustive as provided under Section 14. It merely states that no suits and proceedings can be initiated against the corporate debtor. However, the liquidator may, at the behest of the corporate debtor, to further its interests, may initiate any proceedings for either recovery of money or for arbitral awards, any such nature, a liquidator may initiate proceedings. And insolvency professional is appointed as a liquidator. As we've discussed just now, insolvency professional who meets with all of the eligibility criteria may be appointed as a liquidator. This liquidator should not be a related party himself, should not belong to um, a firm of auditors that has been catering to the corporate debtor in the past uh, 5 years, and should not belong to a law firm which has gotten over 10% of its revenues from the corporate debtor in the past 5 years, or should not be a partner at such an IPE where the partners or the directors are representing IPE, meaning insolvency professional entity, are representing other stakeholders, or such partners or directors are related to the corporate debtor or any of the stakeholders. If the IPE or directors or the liquidator has currently or previously had any pecuniary relation with any of the stakeholders, such relation must be disclosed to the adjudicating authority and the insolvency and bankruptcy board. So once the order for liquidation is passed, the liquidation is considered to have commenced. Upon the appointment of liquidator, within 5 days of his appointment, a public announcement shall be issued. So, similar to the CIRP process, a public announcement will contain the details, the basic details of the corporate debtor, and it will contain how and where and by when claims of the stakeholders are invited. So it will state the date of the CIRP commencement, and it will state, so under the liquidation process, the claims must be received within 30 days of the commencement date. So once the paper publication is made, such date is also provided, which happens to be the 30th day from the insolvency commencement date. And the claims are invited from various stakeholders. So operational creditors may submit Form B, Form C, Form B under CIRP and Form C under liquidation. Financial creditors will submit Form D. Employees and workmen shall submit Form E and Form F if there are multiple employee and workmen and they are going to use a representative to submit all of their claims on their behalf, Form F. And Form G for all other creditors, all other stakeholders. So, we will come to the claims part in detail in the subsequent portions. And once the liquidation order is passed, the liquidator is also required to submit to the MCA, or if it's LLP, to the concerned registrars, informing them that such liquidation proceedings are taking place against the corporate debtor. This process is done even in the CIRP process. So if it's a company, of for a compliance form called INC 28 is submitted to MCA, which if you look at any corporate debtor's profile, under in the basic details, it shows that the company is either under CIRP or either under liquidation. So once the concerned registrar is appraised of either liquidation of CI or CIRP, they will update it on the website. You can have a look at this. So this is a company called DK Realty India Private Limited, and this company, this is the master data information provided on the Ministry of Corporate Affairs website. So this provides the preliminary data of the company, and under company status, it provides that the company is under CIRP. Similarly, this is a company called Visa Power Limited, and for this company, it shows that the company is under liquidation, right? So the concerned registries are required to update it on their platforms as well, so that the stakeholders, if in case they somehow by chance miss out on the public announcement, or for instance on the IBBI website also displays the public announcement that is issued by the resolution professional or the liquidator. Similarly, MCA was also going to provide it in the manner that I just showed you. So now let us understand the role, powers and the roles given to a liquidator. So the role of a liquidator is very similar to that of a resolution professional. A liquidator will take control of all the assets, records, and accounts. So the liquidator's power here is explicitly stated in one provision, that the liquidator, in the regulations, it is provided that the liquidator is empowered to approach any governmental authorities, information utility, any registries of any securities institutions, financial record keeping agencies of any sort, state government, central government, any other local authorities. Basically, any manner in which he deems appropriate may obtain information regarding the corporate debtor to form a holistic understanding of the assets and liabilities of the company, because this is the ultimate death of the corporate debtor. And before such thing can be undertaken, all of the accounts need to be accu- uh, collated and understood. So they will also have access to registration authorities, securities authorities, and banking data and banking information, even the ones that are not provided directly by either the corporate debtor or its key managerial personnel, employees, and even if the insolvency professional who has acted either as the IRP or the RP has also not provided, then the liquidator may take action as provided under Section 19. You remember Section 19(2), which states that the insolvency professional, if he is not receiving support from the key managerial personnel, may approach the adjudicating authority to seek directions, seeking cooperation from the key managerial personnel, employees, and such other authorities. So here the liquidator can file this application as well. He is also empowered to file the same application. However, he can also file it against the insolvency professional who has acted as the IRP or the RP. Verification of claims of creditors and form the liquidation estate. So as I've told you, the forms of various stakeholders is provided by the IBBI. And such stakeholders may submit these forms within 30 days from the liquidation commencement date. Once these claims are submitted, the liquidator shall verify these claims, and for the verification, he may require proofs from the stakeholders as he deems fit. All of the criteria that we have seen under the CIRP process for claim verification still applies here as well. And if the financial creditors are unable to provide records from the insolvent information utility, then they may submit their claims in a manner as prescribed for the operational creditors. So once all the claims are received, the liquidator shall shall constitute a stakeholder committee. So the stakeholder consultation committee is constituted nine within 60 days of the insolvency commencement date, or 45 days from the receipt of claims, whichever is later. So we'll understand about the role and functioning of the stakeholder committee in the subsequent portion. So once the claims are verified, the liquidator holds a slightly varied position in claim verification than a resolution professional or an IRP. He is empowered to adjudicate the claim amount. He may either reject it or accept it. So, since he is empowered with this uh, aspect, the stakeholders may approach the adjudicating authority. They may file an appeal upon rejection or accept or the amount which is accepted by the liquidator, and file an appeal before the adjudicating authority within 10 days of such rejection or admission. Once the claims of all these creditors are collated, the liquidator may form a liquidation estate. We will see in the next portion what a liquidation estate is. So the liquidator, once the liquidation estate is constituted, he may sell the assets of the corporate debtor via either auction or a private sale, and subsequently distribute all the proceeds as per the waterfall mechanism. Once the liquidator is appointed and an order for liquidation is provided, is issued by the adjudicating authority, it is also an immediate suspension and termination of all the employees is also part of the liquidation order. So by issuing or by passing the orders for liquidation, all of the employees also get terminated unless the liquidator either retains them for the continuation of the conclusion of the liquidation process, or their corporate debtor is being sold as a going concern. So the liquidation process is as stipulated under the code. It is for a period of 1 year. If such employees or professionals assistance is required, the liquidator may have them on board or appoint such other professionals to assist him in the process of the liquidation, or to keep the corporate debtor as a going concern. The liquidator is also empowered to appoint such professionals to ensure and preserve the value of assets of the corporate debtor. Coming to distribution of proceeds as per the waterfall mechanism, we will understand that in the next session. Now let us understand what is a liquidation estate. So a liquidation estate effectively includes tangible and intangible assets, land, machinery, plants, and trademarks of the corporate debtor. Secured and unsecured assets, assets pledged as collateral, and free assets. So, any assets that are of the corporate debtor and are held in the name of the corporate debtor, or in which the corporate debtor has a direct interest, or such interest has been vested in the corporate debtor, will be part of the liquidation estate. But coming to the secured assets, the assets, so a secured creditor will be given an option under section 52 of the code. A secured creditor may opt either to relinquish his security interest into the liquidation estate or to proceed in realizing his due amount by liquidating the security interest. So ordinarily, how will you assess if a security interest is to be relinquished or not? If in case there is a property worth 100 crores and the financial creditor, secured financial creditor holding such security interest is going to be realizing a lower amount in the waterfall mechanism, then they will suppose say they have a debt due towards them worth of 50 crores. But if they go as per the waterfall mechanism, the the potentially realizable value may be lower. Supposing it may be lower, and since they are already covered by such a huge security provided, then they will not relinquish into the liquidation estate. However, since even subject to realization of the due towards them, there will be an amount left, a 50 crore amount left. So this amount will have to be given back to the liquidator, which will ultimately be made part of the liquidation estate. So if in case the secured creditor chooses not to relinquish their security interest into the liquidation estate, then such asset, which is the collateral, will not be part of the liquidation estate. But this information needs to be provided to the liquidator within 30 days of submitting their claim. Under CIRP, all of the stakeholders, whoever have submitted their claims, will have to submit their updated claims in the liquidation process upon the issuance of a public announcement. If there is any variations or increase or decreases in the claim amounts, or if in case they want to withdraw the claims, then they may do so in the liquidation process. And generally, because the CIRP has gone on for 330 days, there is a possibility that the interest amounts have accrued and the claim amount will vary. So such updated claim amounts will be submitted. And once the updated claim amount is verified by the liquidator and accepted, so the claim amount of the secured creditor also is subject to such variation. and whatever claim that they submit, within 30 days of submitting such claim, they are required to intimate the liquidator whether or not they are going to relinquish their security. If they do not want to relinquish the security interest, they have to inform the liquidator within 30 days. However, if they do not inform the same, then it is presumed to have been relinquished into the liquidation estate. And assets subject to legal proceedings. Assets under litigation, but that are recoverable by the corporate debtor, will also be part of the liquidation estate. And any securities held directly in the name of the corporate debtor will be part of the liquidation estate. Now let us understand what are the exclusions in the liquidation process, in the liquidation estate. So ultimately, any asset that is not held in the name of the corporate debtor will not be made part of the liquidation estate. For instance, personal assets of the promoters or directors, unless acquired through fraud. So, any of the assets of the promoters or partners or directors of the corporate debtor will not be a part unless and until such assets are also under scrutiny for avoidance transactions and or have been obtained from the corporate debtor, or which was supposed to be the corporate debtor's asset but was fraudulently taken over by the promoters or directors. Such assets will not be will be included in the liquidation estate. Assets held in trust or fiduciary capacity, such as bailment contracts. So any third party assets that are held by the corporate debtor as for in any such capacity in a fiduciary capacity will not be included in the liquidation estate. Operational funds necessary for business continuity. Also, the assets of a subsidiary company, or either a foreign subsidiary or an Indian subsidiary, will also not be included in the liquidation estate. Any amounts that are due to be provided to the employees, like a provident fund or gratuity benefits or such other amounts which have not been provided, are the assets technically of the employees, and hence it cannot be included in the liquidation estate. Or any assets that are subject to set-offs by either a financial sector institution and such other similar contracts, which are basically any assets that cannot possibly be in the name of the corporate debtor will not be included in the liquidation estate. As I've just told you, the liquidator is empowered to access various registries, information utilities, and credit facilities and such other institutions. So basically, if in case, supposing there is a land that is purported to be of the corporate debtor, then the liquidator is required to verify if such document, if there is substantial documentation to actually prove that that asset belongs to the corporate debtor. He has access to the registries wherein if such claim of the corporate debtor is disputed, he can verify with the registration authorities. That will ensure that all the assets included in the liquidation estate are completely owned by the corporate debtor alone. Because if in case in the future there is some dispute and someone else wishes to claim, then the corporate debtor has already been resolved at that point. It may not even it may not even have an opportunity to submit a claim. So any award holder or any decree holder against the corporate debtor is also required to submit a claim as other creditors, and such other creditors will also be included in the stakeholder committee. So let us understand the process of liquidation. So we will understand what is the process of liquidation and its respective timelines in this lecture and in the subsequent lecture. So when the liquidator submits a stakeholder consultation committee constitution report to the adjudicating authority, he effectively once the stakeholder committee is constituted, they will take charge of the liquidation proceedings and appoint such insolvency professionals as the liquidator. So effectively, the stakeholder committee will play the role that a committee of creditors has played in the CIRP process. So the stakeholder committee, before it is constituted, so the first meeting of the stakeholder committee must be conducted within 7 days of the liquidation commencement date. However, at that point, the stakeholder committee is not constituted, so the committee of creditors will only continue as the stakeholders committee as well until the stakeholder committee is constituted. So, and such stakeholder committee will have powers to vote in proportion to the debt owed to them. All of the stakeholders of the corporate debtor will be made part of the stakeholder consultation committee. This stakeholder consultation committee also includes operational creditors and they are given a voting right. However, any related party or any representative of the corporate debtor, erstwhile management directors who are appearing in the meetings as a representative of the corporate debtor will not possess any votes, or any other financial creditors or operational creditors who are related to the corporate debtor will also not have any voting right. Other than these, all of the other stakeholders will possess voting rights in proportion to their debt against that of the total debt of the corporate debtor. So the stakeholder consultation committee may convene, and even in the stakeholder consultation committees, the liquidator acts as the chairman and proposes an agenda unless such other items are if in case such other items are also proposed by the uh, stakeholder committee, then the liquidator will include such items in the agenda and put it before the stakeholder committee. In every meeting of the stakeholder committee, the liquidator is required to provide the costs incurred, the progress that he has made from the previous meeting of the stakeholder committee needs to be provided in the meeting. And once the stakeholder committee meeting is done, he is required to communicate and record such discussions in the form of minutes and distribute it to all of the stakeholders. So any voting or any suggestions given by the stakeholders are merely suggestions to the liquidator. The liquidator is not bound by the suggestions provided by the stakeholder committee. He may choose to accept these suggestions and act in accordance, or he may act as he thinks appropriate, take such action as he thinks appropriate. But if he does take action contrary to the suggestion of the stakeholder committee, he is required to provide in writing reasons for having done so. And all of this needs to be communicated to all of the stakeholders who have either participated and who have not participated in the stakeholder consultation committee. So we will understand the process of liquidation, the role that the stakeholder committee plays, the role that the liquidator plays, and how the corporate debtor ultimately is distributed and dissolved in the next lecture. But this is all for today. Thank you.